I'm still waiting for all of you guys on, we need everybody.
Yes, I have trial starting in 10 minutes, so I'll be just next door. You can break in Judge Johnson and ready for me, I guess.
That doesn't sound very promising. Who are we missing?
Mr. Sheets.
I think we're just missing Mr. Sheets.
Okay, we'll go forward without him as we have 6/7 of our attorneys, which is pretty good given a 7 co-defendant cases. So let's call page 15, Raven Queen, page 17, Antonio Washington, page 18, Denzale Lee, page 19, Sjean Jackson, page 20, Antwain McDuffie, and page 21, Howard Cavitt. We will trail Lamonte Butler until Mr. Sheets gets here. All right. We are on for a motion to admit evidence. Did you want to be heard any further?
Your Honor, we did receive an opposition only from Mr. Lee at this point in time. I'd be happy to address any of the points he made, and I think it's thoroughly addressed in our motion.
Okay, well, let's start with Queen. Mr. Langford, are you on?
I am, Your Honor.
Any objection to the motion to admit video evidence pursuant to NRS 48.0452?
Well, my concern, Your Honor, is that we continue to have discovery released, and I'm not sure how that impacts. So, and it's pretty early on for having evidence admitted. I guess if we wanted to conditionally admit it, and so it helps the state in some fashion, I guess, to understand their strategy. But I just think that it's a bit early, considering the continual release of discovery, for us to say definitively we won't have a challenge to the foundation or to the relevance. I mean, it seems pretty clear right now, but I don't know how the court wants to handle that.
So at this point, I will grant as to this defendant, but I find that it does go to plan, scheme, or motive, it is substantially probative and not outweighed by prejudice. However, I'm going to edit out the last line that includes the racial slur. I'll ask that you stop before that part, as the prejudice outweighs the probative value.
We will, could we edit that out by striking the audio, or do you want the video to end before?
You could just end it at that point, or strike the audio, either way, as long as it doesn't say that.
Okay.
You know what I'm saying? Okay.
And Your Honor,
Mr. Langford, if there is a change if you get any discovery that changes your position on it, you would be entitled to bring a motion to reconsider, and I would consider that changed grounds.
Good, thank you, Your Honor.
Okay, and then you also filed a motion to continue. Do you want to address that at this time, Mr. Langford?
I don't know if the state's had an opportunity to look at it. I apologize to them. I did send them a courtesy copy yesterday.
I'll summarize. You received 24,000 pages of medical records and jail calls.
And some jail calls and some additional video. Yeah.
Okay. What's the state's position on a global motion to continue here?
If it's joined by all defendants, the state has no objection to a continuance.
Okay. Regarding trial, Mr. Green, you had filed a motion to continue as well.
That is correct.
So
we
it
did
sounds
file
like
a supplement indicating the 644 pages in one file and 2.1 gigabytes in another file with thousands of pages, which it took almost 2.5 hours to copy that from the state's submittal online. And we still have to go through it. There may be some duplicate, but we still have to look at it.
Okay.
So
it sounds like you don't have, you're not only not opposing the motion to continue, you're making your own request.
that is correct. We filed one several weeks ago with a supplement, I believe Thursday or Friday.
Okay. Mr. Hendron, I know I'm going to get to the motion itself, but regarding the motion to continue, what's your position?
No opposition, Judge. Can join in on it then.
Okay. Mr. Patrick.
Same, Your Honor. No opposition, and we'll join in the motion.
Mr. Rutledge.
Yeah, he's saying,
Mr. Nicholson.
Yes, ma'am. Same.
Okay, so at this point, then I will grant the motion to continue. If Mr. Sheets has an opposition, we will address that separately, but I can't anticipate he will.
Based on a phone call that I had with him on Friday, I would say that he's not having an objection to the motion to continue.
All right, Mr. Langford, you are sort of leading the charge here. What sort of timeline were you looking for?
Anything before 2025?
Okay.
What about either 10/9/23 to 11/6/23? If that doesn't work, I can look at January dates, which would be 1/2/24 to 1/29/24.
Your Honor, I'm available the latter part of October, but the first 2 weeks I'm not.
Okay, would October 30th work for you?
I believe so, yes.
I'm hoping that works. Anybody have an issue with October 30th? Yes, Mr. Hendron.
We start a trial that I anticipate will be going on October 23rd.
Okay,
And I anticipate it might even spill over then to the following week as well.
okay. Does November 6th work for you, Mr. Langford?
Yes, Your Honor.
Anyone with issues with November 6th?
No, we were gonna request November 6th or 8th.
All right.
February
Seeing
5th.
no stringent opposition to that, I assume that'll work for the state.
Yes, Your Honor.
We're going to reset this trial date for November 6th, 2023 at 9:30 a.m. with a calendar call of October 30th, 2023, also at 9:30 a.m. All right?
Thank you, Your Honor.
All right, Mr. Langford's free to go. Mr. Washington, regarding the motion to admit video evidence, on behalf of Mr. Washington, Mr. Green, what's your position?
We join in the comments made by Mr. Langford. We would add that if it is admitted, even with the court striking, comparing some of the new discovery which we have received, we may request a limiting instruction on that, or maybe in a further reconsideration, depending on the review of the additional material which has been received last week after the motion, and then perhaps in the future. That's our position.
Sounds good. I will grant as to this defendant with the same caveat to edit out it's the same evidence that's being admitted, so that's already been done. It goes to plan, scheme, or motive, substantially probative, not outweighed by prejudice. And so it will be granted. Obviously, if there's anything that comes up in discovery, that would form a basis for a motion to reconsider, okay?
Thank you. And a limiting instruction, yes, Your Honor.
If that's something that comes up, let me know
Thank you.
what you're requesting. Mr. Lee, you turning to Mr. Hendron for Mr. Lee. You may be heard on your opposition.
And Judge, I'm just wondering if, based on what the other co-defendants are saying, if you would like to, we can defer any ruling on this. If there is additional discovery that I come upon as well, I could always file a motion asking to bring this issue up to the court's attention. But at least that way, if there is stuff, we're not having to relitigate issues.
So I have read through your opposition, and your argument is that he can establish that Lee himself actually participated in this conversation or received the message, and the probative value is substantially outweighed by the prejudice. I do find that in this case, he is in Mr. Butler's phone as a nickname Mac. This defendant is the only one who actually not really did acknowledge getting it because he loved or liked the video. And so at this point, I'm going to grant the state's motion over objection by Mr. Hendron, with the same caveat as to the evidence, and the same caveat that if something new comes up in discovery, you have an option to file that motion to reconsider.
Thank you.
All right. Sjean Jackson is page 19. I'm going to actually find on this one that he was not sent the video, and it's wholly inapplicable to him. And so it's denied as to him. So the way that we're going to do that is to do a limiting instruction before playing it that says something to the effect of, this defendant was never sent this video. It should not be applied to his case in any way. Does that sound appropriate?
That's
Mr.
what I was
Patrick?
going to ask for, Your Honor.
Okay. We had also taken a writ off calendar indicating that this case might be negotiated. Where are we at with that?
Judge, we're still in the process of negotiations. I still believe that they will come to fruition. So I
Okay.
think at this point we can just leave the writ off.
Okay, sounds good. And so that's then handled for Mr. Jackson's matter. McDuffie, where's Mr. McDuffie? Where is he?
Oh, he's not here present, Your Honor. I didn't know we needed him for this hearing.
Any objection to excusing Mr. McDuffie's appearance for today's date?
I'm sorry, what was the representation, Mr. Ware?
I didn't know we needed him for the, I didn't realize we were doing the motion to continue.
No
I
objection.
thought it was just on for the, argument as to the video evidence.
Just because he's not here, can we do an admonishment then of the trial dates, a written
Yes,
admonishment?
yes, Your Honor.
Perfect. We'll excuse his appearance with that. Any position regarding the motion to admit evidence?
Yes, Your Honor. I don't object to the evidence.
Oh, actually, you have the same exact ruling as Mr.
Well,
Jackson.
I'd like to, a little bit different on that,
Okay.
just to point out. 2/3 of this evidence has absolutely nothing to do with my client. 2/3 of the crimes have absolutely nothing to do with my client. As looking through it, and I think because of that, the prejudice substantially outweighs the probative value as to him. However, I realize it's probably better addressed in a motion to sever, which I will file.
Okay, sounds good. So at this point, I find that he's similarly situated to Mr. Jackson in that this evidence doesn't apply to him in any way. And so it's denied as to him, and we'll address that at this point with a limiting instruction before playing it, that this defendant was never set in the video. It shouldn't be applied to his case in any way. And then it looks like a motion to sever is forthcoming. Okay, moving to Cavitt, page 21. Mr. Nicholson, what's your position regarding the motion to admit video evidence?
I have no objection with the same caveats that we can file a motion to reconsider. We discovered or if the state has anything along those lines. And I suspect during trial we can argue what portion of anything applied or does not apply to our client.
Of course.
That's all I have.
Sounds good, Mr. Nicholson. So granted as the same findings as other defendants with the same editor.
And could you say the three bases again, Judge, that you're...
So regarding Mr. Cavitt, I do find that it goes to plan, scheme, and motive, and I do find it is substantially probative, not outweighed by the prejudice in this matter.
We understand.
Previously, had you said knowledge?
I had not said that one.
Not knowledge, okay. Is this...
I didn't quite understand that argument as much, but I think the three it does fully apply to and is very probative for those. And that's why the prejudice does not outweigh it.
Is the state free to argue only with regard to laying the authentication basis identity? So not necessarily identity as one of the bases to get in, but when we are doing the authentication of the various cell phones and who was on this text thread and then who was found at that subsequent house during the arrest.
I think, of course, that would be, you would need that to establish any sort of foundation or establish that the scheme applies to these people, motive applies to these defendants. So, yes, you would be able to argue that. Otherwise, it would be kind of...
Perfect. I just didn't want identity to be said during some of the base questioning and that to be conflated with the basis of your ruling. That's all.
Right. Of course, you'd have to establish this. This ruling is subject to foundation being laid, but it sounds like there's really not an objection to that at this point. Okay. All right. So I think that's it. Is there anything else we need to address in this matter?
And at this time, from the defense of Mr. Washington, Your Honor.
All right. We'll get Mr. Patrick out of here. Thank you, everybody. You may be seated.
Thank you, Your Honor.
I do need the state, at least one of you, to stick around when Mr. Sheets appears.
No problem.